A substantial change in circumstances under which one can petition the court to modify custody in our state is a change in circumstances which is going to cause an impact to the mental, emotional, or physical health of the child or even of one of the parties that's involved in the case. So take, for example, that one of the parents has abused the child or has behaved in such a way so as to emotionally damage the child. Like I had in one case that we were able to show that the entire living condition of the father was changed, that he was inviting stowaways to live in the home that created a rupture in the welfare of the child. On another case, we had a father who was given to angry outbursts, who was clearly acting vindictively towards his ex. Because she had a new partner, she was dating somebody else. These are the types of things that can be asserted before the court, that are substantial changes that the court should allow one to return and modify a prior custody arrangement. So after divorce, parenting time is modifiable at any point. In other words, parenting time is much easier to modify as compared to parental responsibility. Parental responsibility, which is the ability to make decisions, is much harder to modify. And there really have to be significant changes, we call substantial change in circumstances, that really affects, importantly, the life of the child, welfare of the child, to allow decision-making to change, right? Because the involvement of both parents in the life of the child, particularly if it's been decided already in the divorce court, is something we want to preserve. We want both parents to be making decisions. We want both parents to be actively involved and invested in the child's upbringing. So that's something that's very difficult to modify. And we have to see something significant having changed in order to modify decision-making. However, parenting time, anything can change that might change parenting time. Somebody's work hours changed. The child's class schedule changed, or extracurricular activity changed, such that the parenting schedule needs to be modified. So because such a thing is much more mundane and common, it's much easier to change before the court. So in-state relocation is typically subject to provisions in a divorce judgment or an allocation judgment, which states that either parent is not permitted to move a certain number of miles, say 50 miles, without consent of the other party. And if they do such a thing, then they can be hauled back into court under what's called a petition for rule to show cause, which one could even be jailed potentially as the ultimate consequence if they flaunt the rules of the court. So there is a constancy that the courts like to see in the life of the child, even within the state. However, leaving the state is much more complicated. Almost always it's required that one file a petition for leave to relocate the minor child in order to move out of state with the child. Obviously, this is a much more drastic change. Typically involves a cultural shift from one state to another. Everybody knows life in Chicago is not necessarily the same as in, say, rural Mississippi. And so schools and the connection to relatives and other important individuals in the child's life are likely to be dramatically altered as a result of moving out of state. So there is a formal process that is required, absent an agreement of the parties, to petition the court to relocate out of state. And often these cases can be as big and as involved and as full-blown as an original custody case in the original divorce or parentage process can be, with witnesses, with experts involved, even a trial. So there exists an important statute called the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, that is a state statute, but it's one that exists in all 50 states. Under this statute, the law states that the last 6 months in which the child has resided is presumed to be the home state of the child. So if there's a case in which a child leaves the jurisdiction, one of the parents just moves away, and that child is in that other state for 7 months, let's say, then that state is the home state of the child for the purpose of going to court. Now, this is really, really important because if one is present in another state with the child and has the right to go to court in that state, then that court is most likely to award custody to that person in that state, because that court is in that state and it's the one that's supervising and involved in the life of the child in a much more direct way than the original state. So the 6-month rule is extremely important, and it's necessary to keep in mind, because if your spouse or your ex takes the child out of state, you better act, and you don't agree with it, you better act within 6 months.